and appeal in the matter of Astronics Advanced Electronic System and others, and Lufthansa Technik AG.
Yes, Mr. Hall.
My lords, we had the statute open yesterday afternoon, JA1,
Yes.
tab 1, page 23.
Yeah.
And we were discussing the differential treatment which the Act applies to the patentee and to the exclusive licensee. The exclusive licensee's only route to bringing a claim for infringement is via Section 67. And the title of Section 67 suggests, as it is concerned with, regulating proceedings for that claim for infringement brought by the exclusive licensee. If the licensee brings such a claim, however, the consequences are not the same as if the claim were brought by the patentee. And that is true in two respects. The first is in Section 67 sub 2. And this is the section which allows the court, if the exclusive licensee is successful in proving its infringement claim, it allows the court to take into consideration the position of the exclusive licensee when awarding damages or profits. But this Section 67 sub 2 is expressly restricted to in any such proceedings. So the exclusive licensee's ability to seek, to invite the court to take into account its position is contingent upon it bringing a claim for infringement under Section 67 in the first place. It has to win that claim, and then in those proceedings it can seek to prove its entitlement by having the court look at its license. The second difference between the patentee and the licensee is in Section 67 sub 3. Because in any action brought by the exclusive licensee, the patentee shall be made a party. There are no equivalent provisions that reflect these in Section 61. Section 61 doesn't contain a provision by which the exclusive licensee is joined as a party. So in a patentee's claim under Section 61, the exclusive license, if the exclusive licensee hasn't separately exercised its right to sue under 67, then it's not there. There are no such proceedings as are referred to in Section 67 sub 2. And so in the patentee's claim, there is no statutory warrant for the court to take into consideration the rights of the exclusive licensee. Now, that submission is most apparent, clearly apparent, when one considers the purpose of Section 67 in the first place. It's conveniently cited in a passage in the judgment at 634 on page 351. The judge here is referring to my Lord Justice Arnold's decision in Newham and Generics, and he cites there the Swan report, which was the precursor to Section 67, and perhaps I can invite my Lords to read that.
So if, as in this case, the patentee doesn't claim damages but claims an account of profits, but the exclusive licensee has in fact suffered a loss because of diverted sales or whatever, does he have any remedy at all?
In that scenario, the exclusive licensee brings its claim later under Section 67. The patentee is joined to that claim by Section 67(3), and then the court has before it the infringer, exclusive licensee, and the patentee who has already made the first claim. The situation can be resolved then. And it may be that...
How would the court resolve it?
Well, that could depend on various different circumstances, my lord. In that case, if the patentee was entitled to bring a claim without the exclusive licensee there, then there's no problem for the exclusive licensee. It hasn't suffered any unfairness by the approach. Perhaps the exclusive licensee agreed. Perhaps the exclusive licensee said to the patentee, I don't want to bear the burden and the cost of litigation. I'm going to leave that to you. I'm going to sit back and let you deal with it. In those circumstances, it may be said that the exclusive licensee could and should have brought the Section 67 claim at the same time as the Section 61 claim, and the two could have been consolidated. And it's an abusive process for it to seek to bring a second one. But it would depend on the facts in my submission.
I'll ask a different question. In a case where you have patentee and exclusive licensee in infringement, is the claim for infringement one cause of action vested in two joint claimants, or does each have a separate cause of action?
The Act creates separate causes of action that must be in respect of the same. Yes, the Act must create separate causes of action.
But if they're separate causes of action, what's the rationale for requiring the patentee to be joined?
Because the patentee's cause of action allows it to claim relief. The exclusive licensee's cause of action allows it to sue for infringement, but only in respect of relief allows the court to take its position into consideration. It's not a given that it will get the same relief. So the nature of those two causes of action are different. And the relief, a profits case is a good example, the relief may overlap. So it may be that if an exclusive licensee brought a claim under Section 67, and it would, and it had its entitlement taken into account under Section 67(2), let's say the court determined that it was entitled to 30% of the profits. That's its share, either because of the terms of its license or because there are no terms of the license and it's implied into it by statute. So it's got a 30% share. Imagine that the patentee had brought the action in Section 61 and not involved the exclusive licensee. If that were the case, the patentee would have over-recovered. It's taken the 30% share to which the exclusive licensee is entitled. So when the exclusive licensee brings its later claim under Section 67, the infringer will say, I've already paid out. There aren't any profits left to disgorge. Everything factually and legally caused has gone. And the answer to that is that the patentee is joined everybody knows that the patentee over-recovers. And the action for recovery for the exclusive licensee's share is as between it and the patentee. Breach of contract or breach of license. And of course, if one considers the position the other way around, if the exclusive licensee sues first, then the patentee is joined to make sure that the patentee is bound by the outcome. Because otherwise, the patentee could come back under Section 61 and seek to recover all the profits. Then the infringer would have to pay out twice. So Section 67(3) protects
so
the
in your
infringer.
submission, what is the rationale for requiring an exclusive licensee to join the patentee, not the patentee to join the exclusive licensee?
Because the patentee has a right to all the profits. And the
That seems to be a statement that it has an absolute right to all the profits.
it's
Whereas what
that's-
you've just
yes.
been submitting would run counters.
that's its right in its right in Section 61 is unfettered. If the patentee brings a claim for profits, in this context we're talking about, its entitlement is absolute. There's no share, no warrant for taking into consideration the exclusive licensee's position.
What if the patentee wants the account of profits, but the licensee says, well, I've suffered losses, and I want damages?
There's authority on that, and the authority is that both exclusive licensee and patentee have to take the same election. That's Mr. Justice Pumphrey.
Who decides if they're in conflict?
Beg your pardon?
Who decides if they are in conflict?
This all depends on. It depends on the order in which things go. So I think it's worth, before answering that question, if I can just consider why I say that Section 61 doesn't include the warrant to take into consideration any profits to be awarded to the exclusive licensee. And the reason is that, assume against me that it did, that would mean there were already in Section 61, inherent in the statute, a warrant for the court to take into consideration the profits derived from the infringement, so far as it constitutes an infringement of the rights of the exclusive licensee as such. Premises that is already built into Section 61. If that's right, then the words in Section 67(2) serve no purpose at all. So the fact that the words are in Section 67(2) tells us that they aren't in Section 61. And that's the bedrock to my case, is that, therefore, when the patentee brings proceedings under Section 61, the court doesn't have any warrant to take into account its the position of the exclusive licensee. You see that in respect of damages in the citation there that I showed you in the judgment, and I've explained to you now why the position is the same in respect of.
Just on a quick question of housekeeping, we've got to have enough time to deal with the next appeal, so I think I'm going to have to ask you to finish by 11 o'clock at the latest.
I'm sorry, Mark?
11 o'clock.
11 o'clock. Okay. And so, to answer your question about the rationale, the question was if the exclusive licensee has claimed profits, but the patentee has claimed profits, but the exclusive licensee wanted to claim damages. So the patentee went first in section 61, and it was entitled to claim profits under section 61. The court had no warrant to take into account the exclusive licensee's position. Patentee's rights take primacy, and it has made the election. If the exclusive licensee knew about that, there is no problem. And that must be the situation in the vast majority of cases, because the patentee and exclusive licensee are bound together in a working contractual relationship. If the exclusive licensee didn't know about that, the question is whether the patentee has done something that it wasn't entitled to do under the terms of its exclusive license. And that may be the terms as expressed, or the terms, I think my Lord Justice Arnold suggested yesterday, and Lord Justice Lewison, that perhaps there is inherent in the exclusive license, the statute implies some rights in respect of relief. So if the patentee has breached the terms of its license, either express or implied, the cause of action for the exclusive licensee is against the patentee. And in that context, I just want to consider how the two rival regimes bear out on the position of the infringer. So I have my proposition that there's no warrant under section 61, and my learned friend's proposition is no, the court must take into account the exclusive licensee's position. So let us assume that the license has given the exclusive licensee a right to a share. That's in the license. Consider that the patentee brings an action under section 61. It covers all the profits. I've explained to you that the exclusive licensee's action is then against the patentee to recover those profits. To recover its share, patentee wrongly retained. But what if the exclusive licensee doesn't know about the patentee's action under section 61? The exclusive licensee then comes under section 67. The patentee is then joined, 67.3. Everyone finds out about what happened before, and the court can resolve the position as between the exclusive licensee and the patentee, and the infringer falls away. That's my position. So the infringer only gets vexed with one account of profits. In that same scenario, and of course, the outcome is that the infringer pays its profits out once. The patentee ultimately keeps only its share, and the exclusive licensee gets its share. So justice is served to all. And we can contrast that with how my learned friend says the scheme works. Because in his regime, in the patentee's action, it will only recover its share. Somehow, the court finds out about the exclusive license. There must be an order for disclosure.
Registered.
It doesn't have to be
It's
registered.
not mandatory,
Yes.
but there are
Yeah.
incentives to make
So
that.
if it were registered, that would be a very good, easy way to find out about it. But it may not be registered. But assume that the court can find the license somehow and take it into account. The patentee gets only its share. Later, the exclusive licensee comes along. It can't sue the patentee because the patentee hasn't wrongfully retained any profits. So it has to bring an action under section 67 against the infringer for another account of profits for its share. Now, if the exclusive licensee didn't know about the first set of proceedings, which is the premise of this argument, then it's difficult to see why it would be bound by the outcome of that first set of proceedings. So the infringer is vexed twice in two account of profits, possibly with inconsistent outcomes. I say that cannot possibly have been the intention of the Act. The only way my learned friend's construction of it would properly work is if Section 61 contained a provision reflecting that in Section 67(3), requiring the exclusive licensee to be joined. It isn't there. And that's because my learned friend's interpretation is wrong. I should say, in passing, that that doesn't mean there is no benefit to the settlement between the exclusive licensee and the infringer, because by that settlement, the infringer avoids a claim being brought by the exclusive licensee. And we know in this case, Kidd was threatening to do that. And it avoids the risk of the relief that may come from that claim when it's brought. Because, of course, when that claim is brought, the patentee comes along and the rest of it. So there is real value in the settlement, notwithstanding that it has no bearing on the patentee.
Is CPR Rule 19.3 of any relevance to this discussion?
My lord, I don't have CPR 19.3 to hand.
Where a claimant claims a remedy to which some other person is jointly entitled with him, all persons jointly entitled to the remedy must be parties unless the court orders otherwise.
I think my answer to that is that there is no joint entitlement to remedy. The exclusive licensee's remedy under Section 67 sub 2 is to have its license position taken into consideration. Patentee's remedy in Section 61 is profits. My lords, that's everything I have to say about the statutory interpretation point. Now I want to address my learned friends clearly. Unless there's anything further I can help them.
Just one question, if I may. Let us suppose you're right about the statute, and the statute doesn't say anything. Require the court to take into account the position of the exclusive licensee. In exercising an equitable jurisdiction, could the court say, well, the infringer's already paid X million of its profits to the exclusive licensee, and to the extent that it's paid X million to the exclusive licensee, the remaining pool of profits is diminished?
My answer to that is that in proposing that solution, my lord is taking into consideration the exclusive licensee's license and
Yes,
interests.
I am exactly saying that.
Indeed.
I'm saying that we're not required to. The statute doesn't
No.
require the court to do that. The question is, can it?
Well, my lord, I might go further and say not only does the statute not require you to do that, but it prevents you from doing so, because we've seen that it's deliberate in the statute that Section 67(2) is different to Section 61, and so equity ought not to interfere with that which the legislators have intended.
So your point is equity can't contradict the statute.
Indeed. I'm also reminded, of course, that Lufthansa wasn't involved in the settlement. It was in secret, so unlike the regime which Section 67 anticipates, Lufthansa wasn't made a party to the settlement, and so we say it has no bearing on the outcome. Yes, so Lufthansa itself didn't get any benefit from that settlement. So the my learned friend's appeal. Can I start, please, with two principles of construction under German law?
Sorry, just on that last point, I quite understand the point you're making about Lufthansa's position, and I see the force about it. But would you accept that if KID was exclusive licensing, then as exclusive licensee, it did benefit from the settlement.
Yes, we don't dispute that both General Dynamics and KID benefited themselves from the settlement. They absolutely did. But the question on the account is whether that consideration that was given by General Dynamics is a cost that is deductible from its profits claimed by Lufthansa. If it were, it would reduce the pool of profits to which Lufthansa is entitled, but it wouldn't reduce Lufthansa's share of any profits. It's a different suggestion. And there was a pleaded claim to, in that regard, to try to take the cost into consideration, but that claim wasn't pursued at trial. The first principle of German contractual interpretation matters for present purposes is the good faith principle. My own friends have helpfully reproduced that at paragraph 13 of their skeleton. It seeks to ensure that the spirit of the agreement is upheld. It takes appropriate account of the legitimate interests of both parties. And the second principle, which is recorded by the judge in paragraph 657, is that the court could look at, that's on page 359, is that the court could look at previous judicial decisions as an aid to construction. If it wished to do so, it was a matter for the court to wait to attach, but it was entitled to do so. So it's legitimate.
Relevant to that principle in the present case, when what the German courts were considering was whether the agreement was an exclusive license under German patent law, whereas the question for us is it an exclusive license under UK patent?
But it's not just the license under the German patent that the courts were looking at. They were looking at the scheme of the agreement as a whole. And that's something I'm about to come on to. And I say, based on the evidence that the judge accepted, it is legitimate for this court to look at what decision the German court reached on that scheme. So with those two principles in mind, can we look please at the agreement itself and Article 1, which is confidential bundle, tab 2, page 391. So under this article, KID will, under its sole responsibility, introduce the advanced system to the market, and that's said to involve development, manufacturing, marketing, and after-sales support. Just a word on manufacturing. What KID was doing was manufacturing components, it's making bits. It's not making the assembled power supplies. A word also on marketing. My learned friend said to you yesterday that marketing must include selling. And we don't dispute that, but we say it plainly encompasses more than selling. It means promotion, advertising, offering for sale, etc. I don't think my learned friend went so far as to say that it was restricted to selling. If he did, he went too far, but I'm not sure he went that far. It definitely encompasses advertising and offering. And these acts are expressed to be done under KID's sole responsibility. My learned friends place a lot of weight on these words, and I'm going to come back to them in due course. The second paragraph notes that Lufthansa will participate in any revenues. And just pausing there, the whole point of this agreement is for the parties to make money. The way that Lufthansa makes money is by KID manufacturing these parts that, and then it sells them, and Lufthansa takes a royalty. So that's how the scheme works. And then the third paragraph, this applies only to the advanced system. KID will be free to merchandise the classic system freely without any participation or interference by Lufthansa. So the position is contrasted between the advanced system and the classic system. So how is Lufthansa envisaged to be participating and interfering? The answer to that question we see from the following articles, and I'm going to start, if I can, with Article 4, because that's the first step in the process. This concerns promotion. And you can see that both parties are entitled to promote, and Lufthansa is doing so using existing advertising material, brochures, which are provided by KID. KID makes products. It's not an installer. So the advertising material is for products. Lufthansa is advertising the product. Then we can look at Article 3. This is the installation of the systems. Lufthansa is going to be doing that most of the time. The KID has to recommend Lufthansa. And if the buyer accepts, then Lufthansa is doing it. That includes the first of the 3 bullet points, complete installation of a full turnkey package. And there was some evidence about what that means, and I'm going to come to that in a moment. When it makes that offer, it is also offering, in the 3rd bullet point, certification support. So it's offering support after the products have been purchased and at the installation stage. And when it does so, and this is the paragraph just below the first whole punch, Lufthansa will place an offer for that service in its own name. The intended outcome is a commercially attractive overall offer. Now, can we now look at what a turnkey package is, please? There was evidence of that. It's at 646.
Can you just help me? What is the nature of the evidence and why is it admissible in a construing document?
Beg your pardon, Arnold?
What is the nature of the evidence and what makes it admissible as an aid to construction?
Because, as you'll see in paragraph 646, it is a customary practice. And the principle of good faith.
Customary practice.
Yes. So we should start, my lords, for that. We should start at page 656. Page 358, paragraph 656. And here, this is the good faith principle. And you see the judge records at the top of page 359 how the parties would have understood the declaration, or rather not the party, how a reasonable third party, the position of the recipient, would have understood the declaration in good faith, taking into account customary practices. I think I may have misspoken and said custom and practices earlier on. The term is customary practices.
Do I understand the proposition to be that under German contract law, evidence as to customary practices is admissible?
Yes, that is my submission.
Where do we find that?
And we find that on page 355, paragraph 646, under the heading Customary Practices. And there's no dispute, I should say, that the judge correctly formulated that proposition of foreign law. So this is admissible evidence.
So, where do we find in which you refer out that this is admissible as a matter of German contract law? It may be there, but I'm struggling to see it.
So, in paragraph 656, Mike.
656. So you refer to page 355. So it says 646. So
Sorry, I may maybe say too many numbers. Paragraph 656, page 358. The experts were agreed as to the principle. This is under the heading of
to be sure. To be sure.
Construction.
But we're across purposes. My question is what a German court would regard as admissible evidence. So this establishes that the German court would take into account customary practices.
Yes.
But knowing the way in which the civil courts will work, I would expect that to be a matter for the court, not for the parties to adduce evidence on. So I repeat the question. Where do we find German law that says that evidence from the parties as to what customary practices are is admissible?
I'm not sure we find that. It was common ground. Or neither side suggested that the evidence before the judge was not admissible under German law. My learned friend, Mr. Copeland, took a point that it wasn't admissible under English law because I hadn't pleaded it. But the judge rejected that. Nobody took a point that under German law it wasn't admissible. If there is the point somewhere in the evidence, I'm sure it'll be shown to me, but it wasn't a point that was an issue, so I'm not sure whether it was. We see in 646 on page 355 those customary practices. 646, a maintenance, repair and overhaul facility, that's the third line, of which Lufthansa was one, would control and carry out the entire process from beginning to end. And the final sentence, Lufthansa submitted the meaning of the turnkey package in Article 3 should be understood in that context. I accept that submission.
So there's no reference to any evidence at all.
647, this is where the judge refers to the evidence in support of the submission I made. He refers to the defendant's witnesses supporting that conclusion, a proposal which Lufthansa put in evidence, in which the relevant airline invited suppliers to propose a turnkey maintenance solution to encompass all aspects of maintenance and support of the IFE system. And then he produces an extract from the Valor report, which was an exhibit to one of Astronics experts' reports. And you see 5 lines down, airlines, especially those preferring turnkey solutions and cabin retrofits. The firm can control everything from program management, design and certification to building complete interiors and final installation. So that is the evidence of customary practices. And that is what we need to take into account when we consider Article 3. So when Lufthansa is offering a full turnkey package under Article 3 with a view to making a commercially attractive overall offer, it isn't just offering to install bits. It is offering the airline, an aircraft fully equipped, power supplies, and the rest of it. That's what the customer wants.
What flows from that, given that on your construction, the license, whatever it is confined to the components. So whatever is not covered by the license, the IFE, simply not regulated by the license at all.
Well, the IFE in this context includes the power supply.
Well, I follow. It includes the power supply, which, as I understand it, in turn includes the components manufactured by KID. I'm not quite seeing what significance there is to the fact that this is a turnkey package, which includes a whole lot of stuff which has nothing to do with the license.
Well, I hope to address you. I hope to answer that question in a moment. Because my submission is that what Lufthansa is doing here, when it makes this offer, is it is offering power supplies, That's what it's offering. Or it's offering an IFE system with a power supply in it. It is offering the product that is covered by Claim 1 of the UK patent.
And a whole lot more.
And a whole lot more. But the product it is offering is one that would fall within the claim.
But it's not confined to the claim.
Absolutely, I accept that. I accept that. It's not confined to the claim. But the product it is offering incorporates the invention. And just to be clear, that is also the conclusion that the Karlsruhe court came to in the first appeal. Now that is on in paragraph 664 of the judgment on page 364. It starts at 363, I beg your pardon. Professor Metzger puts the decision in evidence because it was in German, so he translated it. So it's his translation. Excuse me. And you see over the page 364, the paragraph that begins between the hole punches. About 6 lines down, it says, on the other hand, plaintiff, that's Lufthansa's contribution, is not limited to the granting of the license. Rather, it's obliged to provide the best possible support, and as a rule should take over installation, i.e. be involved in placing patent-protected systems on the market. Furthermore, it should be entitled to carry out its own advertising activities and thus to offer the devices covered by the patent in suit. So that is an offer of the product itself. You see in the next paragraph that Professor Ann didn't dispute the translation. So that is an accurate translation.
So in your submission, is that a decision to the effect that Article 4 in some way grants Lufthansa a license?
Well, perhaps we can
back license or sub-license.
Perhaps we can take stock of where we are. My position is that both parties are envisaged in this agreement to be advertising the products and offering them for sale. And one point, and that is an act that is reserved within the Patents Act. It is an offer to dispose of a product that falls within the claim. It would be an infringement of the patent. Indeed, that is precisely the infringement that Panasonic is accounting profits for disposing of IFE systems. Disposing of power supplies, but it's in the context of selling an IFE system. So the offer to dispose of these products is an offer that would be an infringement of the patent.
But why would be an infringement of the patent if key components are made by KID, which is licensed under the patent?
Well, so this is my point. So KID cannot be, in my submission, under this agreement, cannot be entitled to exclude Lufthansa from offering the product for sale. Cannot be. And my learned friend's answer to that is to say, his answer to this line of argument is to say, well, Lufthansa gets its rights through exhaustion upon sale. But at this point, when Lufthansa is offering the product for sale, the sale hasn't taken place. So it cannot get its rights from the sale. Indeed, the products may well not even have been made yet. Or at least, to be clear, there was no evidence in German law that Lufthansa could derive rights in that. But that's a question
of German law. I don't understand.
Well, because
we're talking about whether a UK patent has been exhausted. That's a question of UK law, isn't it?
So I'm talking about the scheme of this agreement and who is excluded from doing what. My Lord may have a point that because this agreement does not exclude Lufthansa from offering products, there is not an exclusive license under UK law to KID in respect of offering products. That may be the end of it. But as I understand it, my learned friend's answer to that is to say, no. KID can exclude Lufthansa because upon the sale of the components, Lufthansa is then entitled to do what it likes. I'm not sure it puts that as a matter of German patent. But in any event, however that submission is put, it doesn't hold because the offer is taking place necessarily before the sale. And my learned friend's second answer to this point is to say, well, KID has an exclusive license under the Acts in Article 1. It's entitled to exclude Lufthansa from the Article 1 Acts because of the words its sole responsibility. So it doesn't matter what happens in Articles 3 and 4. It doesn't matter because it's got an exclusive license in respect of some acts, so it can bring its claim under the 1977. And my answer to that submission lies in the wording of Article 6. So if we could turn to Article 6. The title is Patents and Intellectual Property Rights. In the first line, Lufthansa remains the owner of the intellectual property rights. To be clear, that includes the German patent and the UK patent. Article 6 continues, for which Lufthansa grants to KID an exclusive user's right. That is a singular, unitary grant to KID of some degree of exclusivity in all of that intellectual property. The same exclusivity must apply to all acts, in respect of all patents. The consequence of that is a matter for English law in respect of the English patent, etc. But as a matter of the contract, the same exclusivity must apply across the board. Because those same four words cannot create one type of exclusivity in respect of some acts and a different type of exclusivity in respect of other acts. We accept that there can be multiple licenses granted in respect of a patent, absolutely. But this is a matter of construction of this document. And there was no evidence that those same four words could create different degrees of exclusivity. So because Lufthansa is not excluded from the pre-sale acts of promoting and offering the products, then in Articles 3 and 4, then the unitary grant in Article 6 cannot be one that excludes Lufthansa in respect of any of these articles. And so KID did not have an exclusive license.
Let's assume you're right about that. Let's just take that that's totally correct. What about manufacturing products? Because even on that submission, there's exclusivity in respect of manufacturing.
Well, can I take that point now, Mike? Can we go back to Article 1, please? KID will, under its sole responsibility, introduce the advanced system. Parties agree that includes manufacturing, marketing, and after-sales support. We've seen that Lufthansa is entitled to market. So these words, its sole responsibility, are not excluding Lufthansa from marketing. It can't be, because
it seems to be a repetition of your previous submission.
Right.
My question was about manufacturing.
Well, if those words are not excluding marketing in the third line, they cannot be excluding Lufthansa from manufacturing.
There's a different way of reading Article 6. You ask yourself, for which of the intellectual property rights has Lufthansa granted KID an exclusive user's right? The answer is, well, a combination of Articles 1 and 3 is manufacturing blah, 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 but not offering. And in respect of those rights, Lufthansa remains the owner of the intellectual property rights.
So my submission is, if Article 6 weren't there, it would be fair to say we can look at each article and see who excludes what from the other. But because Article 6 is there, and you have an exclusive user's right, singular.
Yes, but the question is, for which? For which of the intellectual property rights has Lufthansa granted KID an exclusive user's license?
Well, let's
So
take
look
let's
at the
take
remaining
the UK.
articles of the agreement and decide which they are.
Let's take the UK patent. For in the UK patent, Lufthansa has granted to KID an exclusive user's right. It isn't a user's right for marketing, offering to use, or offering for sale. And because it isn't an exclusive right for marketing, in this Article 1, the parties agree that this responsibility, KID's sole responsibility, comprises development, manufacturing, and marketing. If marketing is not exclusive to KID, then manufacturing cannot be either. It's the next word in the sentence. And my lords, that does not offend against the good faith interpretation of this agreement, because the spirit of the agreement is collaboration. Our position is that the agreement allowed both Lufthansa and KID to commercialise power supplies within the agreement, within the collaboration.
So
What the
is it
agreement-
your submission that Lufthansa could have manufactured and then commercialised in competition with KID?
My lord, what it couldn't do was get into bed with a third party. That is the effect of the sole license.
What do you mean by getting to bed?
So
How
Lufthansa,
about the arm's length sale?
so Lufthansa couldn't contract a third party to manufacture. Wasn't permitted to under the contract.
That's not my question. My question is, could Lufthansa itself manufacture and sell
And
in competition with KID?
and the facts are that Lufthansa was not a manufacturer,
So
and
what?
that
It could start. I mean,
and that
you know,
it needed
the
KID.
fact it wasn't previously a manufacturer, how does that stop its beginning to manufacture? Everybody has to start sometime.
My lord, one has to construe this agreement at the time it was struck objectively, according to the principle of good faith, which requires one to consider the positions of the parties and the spirit of the agreement, etc. At that time, Lufthansa was not a manufacturer of components, it was an installer. It couldn't manufacture the components. Paragraph 25 of the judgment, page 16. This is the evidence of Mr. Muirhead. That's Lufthansa's evidence. This evidence is about the position in May 1997.
Paragraph 16.
Paragraph 25 on
25.
page 16.
Yes.
And about 4 lines down from the second hole punch, we needed someone to build it who had the capability to scale a production.
Well, actually, that's no doubt entirely true. But 2 questions. First of all, why does that stop Lufthansa acquiring the capacity to do it if it wanted to do so? Secondly, it might be said, well, that's actually a rationale for granting an exclusive license. It was no skin off Lufthansa's nose, because they couldn't do it anyway.
But what we're dealing with here is the construction of Article 1. I've said it can't be. The word sole responsibility cannot be intended to exclude Lufthansa because of the point about marketing. It just doesn't work.
Yeah, and I think
What I'm saying
we
now
got
is that
point.
that is not inconsistent with the position of manufacturing, because the parties knew the position was that Lufthansa couldn't manufacture. So they didn't need to worry about excluding Lufthansa from manufacture at all. Just wasn't a necessary part of the agreement. On the other hand, if there is an exclusivity in respect of manufacturing, then there is in respect of offering. As we've seen, that prevents prevents Lufthansa from doing the advertising and offering that it was supposedly doing under Article 3 and 4. That doesn't accord with the interests of the parties. And that leaves me with one final point, which is to say, well, what do these words in Article 1 mean? Now, the proposition the judge alighted upon is that he drew some context from the fact that the parties were German and this was German law, and he said the word sole has a meaning in that context, and that is to exclude everyone else apart from the parties. So that was his conclusion as to what that word meant.
As a matter of German patent law.
Yes, although this is an agreement which anticipates within it that there is a license being granted under a German patent. So it's relevant to consider the position under German patent law because the parties to this agreement were considering the position. They were German, the German patent, an agreement governed by German law. So my submission is that the judge's conclusion in respect of sole is a defensible one. There is an alternative proposal. Lufthansa only gets money from this agreement if KID manufactures the components. So the word responsibility could just mean obligation. This is an obligation on KID, enforceable by Lufthansa. It is a duty for KID to manufacture, not a right. And if you turn over the page to 392, if we're still in Article 1, turn over the page to 392, what you see in the final paragraph of Article 1, in exceptional cases, such as VIP acquisition projects, the tasks and duties to be performed by the parties will be adapted. So my submission is that one could read sole responsibility as KID is under a duty to manufacture, which Lufthansa can enforce.
I take the point about responsibility, indeed, in Article 1, it may be talking about duty. But how does that help you when you've got Article 6 conferring the right? Presumably you would accept you have to read the two together.
What Article 6? What Article 6 is doing is that it is saying that any exclusivity is unified across this agreement.
That's the point you made
That's
before.
my submission.
I understand that, absolutely. But you seem to be making a separate point here based on the word responsibility in Article 1 being a duty. And my question was, assume you're totally right about that. Assume in the context of Article 1 it's talking about a duty. How does that help, given that one would assume one reads Article 1 and Article 6 together, and Article 6 is the grant of the right?
Because viewed at a level of exclusivity, Article 1 doesn't allow KID to exclude Lufthansa. So when you look at Article 6 and the exclusive user's right, That is an exclusive user's right, exclusive as against third parties, but it doesn't allow KID to exclude Lufthansa. And that, for the purposes of the 1977 Act, is critical.
Well, I think we've got that point.
What-
I'm sorry, Mr. Hall, but we haven't got all the time in the world.
My Lord, just one very small point that on quantum, my learned friend addressed you on that yesterday. Can I just ask you to take his skeleton, please? Paragraph 72. You'll see at 72, he proposes that he relies on Mr. Bazant's evidence, a typical allocation of between 25% and 50%. And then at the bottom of 74, he says Astronics and Panasonic prefer the second option, that is, please don't send it back to the judge, make a decision at this level. And prepared to accept against themselves the highest end of Mr. Bazant's range. We took that to mean they were suggesting 50%, and we agree, we accept that. I think my learned friend was seeking to row back a bit from that yesterday in his submissions. I think he said that it was more intellectually satisfactory to award KID all the profits. I say he's sold the pass on that. He's proposed 50% here.
You're not inviting us to remit it either.
I'm certainly not inviting my lords to remit it now, and I'm prepared to accept my learned friend's position.
Thank you, Mr.
My
Hall.
lords, if I may just turn my back for a second.
No. I said 11 o'clock, and I mean it.
I understand my lords. Right.
Mr. Copeland, you will have no more than half an hour.
I will need significantly less than that, I hope, my lord. I promise Mr. Purvis I will be quicker. And Mr. Ackland, I think, who's probably next. Marketing includes promotion. That was the point that we've just heard. A lot of that submission was founded on the assumption that you can read marketing in Article 1 to include promotion. Obviously, promotion is dealt with entirely separately in a different article of the agreement. It involves this submission construing the word sole in Article 1 not to mean sole, but to mean joint. My submission, the words taken all together don't permit of a reading where marketing can be expanded beyond selling and supplying to include the joint activity described in Article 4, which is promotion. As regards Article 3, system installation, I don't accept that you can read that as permitting Lufthansa to make offers to sell and supply the components of the system. What it says is, in principle, with this context, Lufthansa may offer the following services, and it sets out what the services are. The services, the fact that it uses the word service as opposed to product, indicates that what it's doing is offering a service. The placement of the offer and the negotiations will be performed to be conducted together with KID to expressly arrive at a commercially attractive overall offer. In my submission, it's very clear that KID is selling the components. Lufthansa is offering its installation services. There's an overall offer. That's what we commercially attractive overall, but what Lufthansa is permitted to do there doesn't overlap with KID's act of supply and sale. In terms of admissible evidence, I did take the points before the judge that there was no evidence as to German rules of procedure about admitting evidence, and I took the point that the experts hadn't given any evidence about what proof was required for that.
Hold on a minute. Yet again, we have confusion. Procedure is a matter for the law of the forum. So it's English law. So if one's asking purely the question of procedural admissibility of the evidence, that's English law, not German law. That's not the question that I was asking Mr. Hall about. My question is whether, if provided that the evidence was properly admitted as a matter of procedure, it would be admissible under German law in interpreting a contract. That's a different question because that's not procedural law, that's contract.
As to that, there was no pleaded case on either side about the admissibility of that evidence, and your lordships don't need me to explain what the consequences of that are in circumstances where there was no evidence led on specifically that narrow point.
So you're saying we default to the presumption that in that respect German law is the same as English law?
Well, I think if the presumption is a justified one, and I just was trying to think through in my head whether the presumption would be a justified one in the circumstances of this case. I think, my lords, I've told you what the law is there, as your lordships know, and I think that's as far as I can go on that.
Did the experts not give any evidence as to the materials a German court would look at in interpreting a German contract?
There was some.
One's experience is that civil law countries normally take a wider range of materials into account in interpreting a contract than English courts do.
My lord, I think I could trawl through whilst on my feet to try and find what evidence there was. My recollection is that there might have been some about the approach of German courts to matters of this kind. With apologies,
You can provide us with the references after the hearing.
I will do what I can.
Specifically, what we're interested in is the approach to so-called customary practices. Because as my Lord Justice Nugee says, and I would agree with this, the tendency in civil law jurisdictions is not to have restrictive rules of evidence, but on the other hand, questions like customary practices tend to be matters for the court, not for parties to put evidence before them. But that's an impression which is no substitute for proper evidence as to what German law actually is.
I will, after the event, rather than taking time now, I will provide references if I can find them or a nil return otherwise. I think then that probably deals with my reply on the appeal. Can I deal now with the respondent's notice on statutory interpretation? Lufthansa's submission yesterday was that the exclusive licensee's entitlement to any financial remedy must depend upon the terms of its exclusive license. The defendant's position is that an exclusive licensee's entitlement to a financial remedy is a product of section 67(1), read together with section 61, albeit that the contract granting the license might purport to regulate how the patentee and exclusive licensee divide any damages or profits award once made, and the court might take that into account when deciding how to divide the profits. But the right of action comes not from the license, it comes from the act. What the license does is it sets out the contractual situation that may make the licensee an exclusive license, but it is the statute that then gives him the right of action. Section 61, subsection D, provides that the proprietor of a patent in civil proceedings may be brought into court by the proprietor of a patent in respect of any act alleged to infringe the patent, and etc. In those proceedings, a claim may be made for an account of the profits derived by him from the infringement, but the reference to the proprietor needs to be read together with section 67, subsection 1, which provides, subject to the provisions of this section, the holder of an exclusive license under the patent shall have the same rights as the proprietor of the patent to bring proceedings in respect of any infringement of patent committed after the date of the license, and references to the proprietor of the patent and the provisions of this act relating to infringement shall be construed accordingly. Section 61 is clearly a provision relating to infringement. So section 67(1) provides, as my Lord Justice Arnold held in the Nugee case, provides the exclusive licensee with a right of action it would not otherwise have. Nugee is interesting because it was a case in which the contract did contain provisions about dividing up damages, at least, and providing that the exclusive licensee could not bring infringement proceedings without the proprietor. But it was held that those provisions don't alter the effect of section 67(1), which gives the exclusive licensee a right of action.
My lords aren't familiar with that authority, so can we have a quick look at it?
That is in the authorities bundle, the third one at tab 65, at page 1967. We need to start with paragraph 19. The contention is that the effect of particular clause 17 made what was otherwise look like an exclusive license not an exclusive license. And my Lord Justice Arnold answered at paragraph 20, the provisions of clause 17 do not alter the effect of section 67(1), which is to give an exclusive licensee a right of action it would not otherwise have. Nothing in clause 17 prevents Flynn from being a claimant, which is why it is the second claimant in these proceedings. Rather, what clause 17 does is regulate how the parties should proceed in the event of litigation. That does not detract in any way from the agreements constituting an exclusive license as defined in section 130. The terms of section 17 are set out in paragraph 13. That's all I wanted to do with that judgment. In my submission, that's authority against my learned friend's submission. Under section 61, the proprietor and the exclusive licensee have a right to bring proceedings in this.
Just a minute. What about paragraph 22? Because that was cited in your skeleton argument. I assume the reason why it was cited in the skeleton argument was because of the reference to its share of the infringer's profits, but it might have said that was all Panasonic.
Well, paragraph 22, I think it's got some history in it. And then it explains the purpose of 67 is to enable an exclusive licensee to recover its own losses or its share of the infringer's profits in the event of infringement. There is obviously a question as to what its share means.
What is your answer to that? I mean, it's easy enough if damages are claimed, because each of the patentee and the exclusive licensee may have suffered their own loss. They have to prove their own losses. How do they prove their share of the profits?
Well, the share is the profits that flowed from the infringement for which the exclusive licensee was an exclusive licensee.
That's why you say logically, if the exclusive licensee has the exclusive license for manufacture, and someone manufactures, they should get 100% of the
That is exactly why I made that submission.
I understand,
That's logically the most satisfactory understanding of it all.
but you're not going back on the 50%.
My lord, I think, much as I would love to, given that we are where we are, I think I'm stuck with the 50% as a question of fairness of procedure to Lufthansa.
Right.
Without detracting from the logic that it should be 100%. My learned friend's analysis yesterday started from the position that the patentee had a right of action, and then one needed to look at the contract between the patentee and the exclusive licensee to see whether it was cut down. And he went so far as to say that in the 1998 teaming agreement there was no provision for KID to have a share of the profits. But he's starting from the wrong place and looking in the wrong place for the reasons I've just given. It's based on the assumption that the patentee has primacy, but there is no primacy because the application of section 61 and section 67 together mean that both the patentee and the exclusive licensee have rights of action. Can we turn to section 67?
Same question. In your submission, is it a single cause of action jointly vested in two claimants, or is it, do they have separate and independent causes of action?
I think the best understanding is that they have separate causes of action, and that either could settle each cause of action independently.
So what happens, what does the infringer do, putative infringer if sued by the patentee, and does or doesn't know whether there's an exclusive license, because it makes a difference on your case as to how much they have to pay. Do they join the exclusive licensee? Do they take it as a defence? What happens?
Well, if he knows about it, then when we get to section 67.2, my submission is that he would be able to say, well, there's an exclusive licensee who has a right to a share of the profits. That needs to be taken into consideration. That, I think, demonstrates the fundamental difference in construction of section 67.2 between me and my learned friend, which is he says that when it says the court must take into account in such proceedings, by which he interprets proceedings brought by the exclusive licensee, that is exclusory of the situation, that's a word, where the patentee sues alone. The court, he says, has no warrant to take it into account. And obviously I say, well, no, what it's saying is that when the exclusive licensee has sued, the court must take that into account, but it absolutely doesn't say that you can't do it otherwise.
So what meaning are you giving to the phrase such proceedings? Proceedings brought by the exclusive licensee or proceedings brought by the proprietor of the patent?
Well, my lord, I did wonder, first of all, whether in such proceedings, which was obviously referring to section 67.1,
Yes.
whether you could look at section 67.1 and say, well, that refers to two sets of proceedings. It refers both to the proceedings that the exclusive licensee can bring, and because it's saying it has the same right, the set of proceedings that the patentee can bring. I think that may be a stretch too far to read it as covering both, and that actually it does say, it does mean in proceedings brought by the exclusive licensee.
So your position then is that if the exclusive licensee brings proceedings, the court must take into account the exclusive licensee, as indeed
Its share, yes.
as indeed you would expect, since it's the exclusive licensee bringing the proceedings for its own loss or for its own claim for profits. But you say that does not preclude the court from, in the exercise of its equitable jurisdiction, from taking into account what the infringer has paid the exclusive licensee as reducing the pool of profits to which the patentee is entitled.
Absolutely.
I think you go further. I think you say, regardless of whether you've paid the exclusive licensee anything, the infringer could could plead as a defence, actually there's an exclusive licence, so I'm only liable for 50% of the profits to the patentee, regardless of whether I've settled or haven't paid anything. Is that right?
I do go that far. You have to take
So
it
it's
now.
not just a question of reducing the pot of profits to be awarded to the patentee, it's reducing the patentee's share to take account of the share which is really the licensee's share.
And you have to take it into account. It may be that it's not right to, having taken it into account, to reduce it because actually there's an agreement between the patentee and the exclusive licensee, which means that the exclusive licensee can never come back for it. But that's all in the mix, as it were, as to what the court does in the interest of fairness when it takes into account the possibility of the exclusive licensee making a claim.
Can I just go back to the question of what proceedings means and the question you were thinking out loud about? What subsection 1 refers to is proceedings in respect of any infringement of the patent. So the question is, do we understand such proceedings to mean simply proceedings in respect of any infringement of the patent?
Yes, that would be.
Hesitating as to whether to go that far.
I'm just trying to process a new point.
The processing can take no more than 10 minutes, Mr.
Yeah. Well, I think, my lord, I think you can read in any such proceedings.
Because if you assume it means proceedings by the exclusive licensee, what is the point of this? Because if it's proceedings by the exclusive licensee, well, of course you'd be doing this anyway. You're bound to do it. Whereas if it's simply saying where you have proceedings for infringement of this patent, then you must consider this.
Well, that makes,
Then it has more bite.
and it makes more sense, my lord.
Maybe the point of section 67(2) is in the last few words, so insofar as it constitutes infringement of the rights of the exclusive licensee as such. I thought that was a point.
Yes, it is, my lord.
You could divide up licenses. They can all be exclusive, but they can be different bits of the.
This is the point my lord made yesterday about how the rights of the exclusive licensee might be in respect of a particular act.
It's only infringement of those acts which section 67(2) allows you to.
It would be very odd if you were taking into account the exclusive licensees, or he doesn't have a right in respect of a different act. I think my Lord Justice Lewison has the point I was going to make about equitable principles in any event, but I think that this construction probably sidesteps that and renders it unnecessary. But I would say that in any event, what section 61 does is it provides for a remedy. The remedy is equitable. So when you're exercising the remedy, equity is there in any event as a backstop. I disagree with my learned friend when he says, well, this act means that you can't look to equity because it's outside the scope of what this act provides for. That is the difference between us. My learned friend gave an example of the situation where the patentee sues first and the exclusive licensee comes along and says, well, I'd like to sue as well. And he said the defendant says, well, hold on, I've paid out to the patentee. And his solution was, well, you have before the court the patentee and the exclusive licensee. So the court says, well, I'm going to, rather than honour the claim by the exclusive licensee against the defendant, I'm going to magic up a claim that's not in existence between the two of you. The exclusive licensee, of course, says, well, hold on, I'm not suing him. My claim isn't, I haven't sued him for breach of contract. My claim isn't against him. My claim is against the defendant. His solution doesn't work. And in my submission.
Can I just go back a step? If we are to apply equitable principles in some way, or even if section 67(2) applies, we must take into account the exclusive licensee. What do you say to the point that Lufthansa was not a party to the KID settlement?
To the
KID settlement.
Well, first of all, I disagree that Lufthansa has not benefited from that settlement. It has benefited from that settlement because the settlement involved the cross-license that enabled KID to carry out its activities, which otherwise it couldn't have done, and of course make money and pay royalty fees. So Lufthansa has benefited from that agreement. So that's the first point. The second point is I don't see, other than as a jury point, why it matters that they weren't a party to that settlement agreement. We're looking here about at the effect on the claim being brought by Lufthansa. The point is that there was an exclusive licensee who had a claim and it settled it.
In its share of the profits, you say that was always KID's share of the profits, and it was for KID to decide what to do with its share, not Lufthansa.
And it settled it. It settled its claim.
And I think you said earlier that it wouldn't make any difference to this argument whether KID had settled or not.
That's right. KID could, if it had a claim, whether it had pursued it, whether it was there before the court, whether it had settled it, it still has a cause of action, a right of action under section 67(1), which needs to be taken into account. We could go on all day, and I'd quite like to, but I think there are other people who wish to have their fair share
Still
of the
got
time.
3 minutes if you want them.
Anything else?
Sorry, the part.
Behind that. That's it, my lord. Unless I can help your lordships.
Right, where do we go next? Is this interest?
Interest is coming last. Double recovery.
Reply on his respondent's notice.
I'm so sorry.
Mr. Hall, do you want to say anything about your respondent's notice in reply?
No.
Thank you. Right, Mr. Appellant.
No, please, your lordships. Double recovery. This is an appeal against the judge's order of the 16th of May of last year, which provides that the sums paid by Astronics and Panasonic are to be treated as having been paid on a final basis. The appellant's case, as it was below, is that the order should have treated those payments as provisional, with liberty to apply to finalise the account upon the conclusion of the parallel proceedings in Germany and France. The judge disagreed, and that was largely a case management decision. Nevertheless, we submit that the decision was founded upon, first, an error of principle. The judge wrongly held that the court has no power to make such an order, and secondly, an exercise of discretion which exceeded the generous ambit that was available to him. And my lords, just generally in terms of timing, I'm going to try to keep my submissions as crisp as possible because there is a fairly weighty interest appeal to come on behind me.
Right.
But I'm going to propose to structure my submissions as follows. First of all, to give your lordships a brief account of the foreign proceedings. Secondly, to describe how the potential for double recovery arises. And then I'll turn to the judgment. So can I start with the foreign proceedings? Can I ask your lordships to take the core bundle tab 29. Page 450. can I just show you the relevant chronology insofar as it relates to the foreign proceedings? So row 7 is the 29th of December 2010. That's the first German proceedings. And Lords, that was an infringement claim against Astronics for the supply of mPower systems directly into Germany. And Astronics was held liable for such acts, both at first instance and on appeal in 2015. You'll note the dates of those decisions are in paragraphs 115 and 16 of the principal judgment. Now, to be clear, there is no potential for double recovery in those first German proceedings because they are concerned only with direct supplies of products into Germany. Can your Lordships then look down to row 14? There's commencement of proceedings in the UK against Astronics and Safran. And in France, the French proceedings were commenced against Astronics and Panasonic. Now, it's not referred to in this particular chronology, but in paragraph 119 of the main judgment, the judge explains that on the same day, that is to say the 29th of December 2017, Lufthansa commenced a second infringement claim against Astronics in Germany, what he called the Mannheim 3 proceedings. And it is those proceedings that give rise to the potential for a double recovery in Germany because they relate to mPower parts which were supplied by Astronics to customers outside Germany, but which parts ultimately shipped into Germany. And the German courts have found, both at first instance and on appeal, that Astronics is liable where it knew, or ought to have known, that the parts in question would ultimately infringe the German patent. And the dates for those liability decisions are recorded in the main judgment at paragraph 119. First instance was December 2019, appeal 12th of July 2023. Back to the chronology, row 16, you'll see a reference to the UK proceedings commenced against Panasonic. And then in row 21, 24th of February 2023, Lufthansa patent revoked in France. That's a reference to the Court of Appeal in France upholding the decision at first instance for revocation. And you'll see in the chronology, the revocation has since been quashed and validity / infringement proceedings are ongoing in the French Court of Appeal. The issue of validity has been remitted back to the Court of Appeal. And I'm told that there's going to be a hearing on validity in that court in October later this year. And if valid,
Validity.
yes. To be clear, validity only has been remitted back to the Court of Appeal. The Court of Appeal is going to decide on the issue of validity. If the patent is upheld, there will then be infringement proceedings running behind it. Now, I'm going to focus, if I may, Your Lordships, on double recovery in the context of the German proceedings, by which I mean Mannheim 3, since those proceedings are substantially further advanced than in France. And insofar as the French proceedings gives rise to any different issues, I'll deal with that at the end. Now, the German proceedings are now in the quantum phase, and the evidence before the judge was that Astronics has provided accounting information that covers mPower products that were shipped to the United Kingdom and then from the United Kingdom to Germany between 2007 and 2018. And so that covers the entirety of the relevant periods for both Astronics and Panasonic in the UK proceedings. And the accounting information included parts that Astronics shipped into the UK, such as to seat manufacturers, and which parts were then shipped to Germany, and also parts that were supplied to Panasonic in the United States, which were then supplied by Panasonic to the United Kingdom, and which were then shipped from the United Kingdom to Germany. And for your note, that is the evidence that is in Supplementary Bundle tab 9, paragraphs 10 to 12. Now, the current state of play is that the ball is in Lufthansa's court. They have to identify the infringing shipments and the sums to which they say they're entitled, and the court will then adjudicate. I can't tell you, because I don't think anybody knows, at what point the German decision is going to, the German court will adjudicate. So may I now just turn briefly to how the issue of double recovery arises. And may I give you just two very simple examples? There is obviously potential complexity because we don't know as yet precisely how the claim is going to be formulated in terms of the quantum phase by Lufthansa in Mannheim 3, let alone do we have a decision. So can I give you one very simple example in terms of Panasonic's profits? The profits which Panasonic was ordered to pay by the judge included the profits derived from its act of infringement in the United Kingdom. That is to say, the supply of mPower components to seat manufacturers in this jurisdiction. If I could ask your lordships to take the double recovery judgment, so that's the core bundle tab 20, and turn to paragraph 47. On page 345. Lufthansa accepted in its reply that it was not entitled to recover profits in overseas proceedings where an award of those same profits had already been made in the account in relation to the same physical products. The judge there refers to Lufthansa's reply. Mr. Jäkel also gave evidence there was a defence of performance under German law, under which the court would permit any damages recovered by Lufthansa in Germany. Finally, Lufthansa did not accept that the potential for double recovery was as great as the defendants argued. In their skeleton argument, they submitted the overlap was far more limited. And could I ask your lordships to read that extract that appears at the bottom of the page and over the next page to line 3.
Yes.
So take the upstream end of this particular supply chain, Astronics and Panasonic. The profits derived by Panasonic from its act of infringement in the UK have already been captured in the account, whereas the profits obtained by Astronics from the supply of components or parts to Panasonic in the USA were not, because those acts of supply did not infringe the United Kingdom patent.
That's this question. Judge speaks about damages, and they quotes a passage which is actually not about damages but about profits.
Yes.
So, what is the nature of the claim in Germany? Because it could be for 3 different things.
Yeah.
Firstly, it could be a claim for what we would recognise to be damages on an ordinary compensatory basis. Secondly, it could be a claim for damages which is quantified by using the infringer's profits as a proxy for the profits lost by the patentee. That is something that some legal systems do. Thirdly, it could be a claim for profits such as we would recognise. So which of those three is the claim advanced in Germany to your understanding?
I'm just checking precisely the evidence that was before the judge.
Well, the judge says it's not clear. Paragraph 46,
Yes.
at least he says you say it's not clear what the claims are.
Well, but paragraph 46 is, it's not clear what the nature of the particular claim is going to be in terms of the scope of the claim. That is to say, the particular acts which...
Clear, I would have thought, where the principle, the legal principle that is being invoked in Germany is compensatory damages in the way that we would recognise damages using infringers' profits as a proxy, or profits as a remedy for unjust enrichment.
My understanding is that of those, it is the second. It is using the damages as a proxy
Using infringers' profits
Sorry.
as a proxy
for the damages.
damages sustained by the patentee.
That's right. May I just go back to the passage that you just read? So what is clearly spelt out there is, notwithstanding that supply chain, it's said that Lufthansa may be able to claim Astronics profits in Germany. In other words, Astronics profits upon the supply of components to Panasonic. Emphasis on Astronics profits. However, my lords, Lufthansa's claim in Germany goes further than that. When I say the claim goes further than that, what I mean by that is Lufthansa has made it plain that it intends that its claim against Astronics will go further than merely capturing Astronics profits on the supply of components to Panasonic in the United States, but it contends that Astronics is jointly liable for the profits which Panasonic earned on the supply of those components into the United Kingdom. Joint liability. In other words, precisely the same profits that have already been awarded in the United Kingdom, albeit paid by Panasonic, and now in Germany, a prospective claim against Astronics.
Maybe you can't be more precise, but if you can be more precise, would you assist us? Because there seems to be two different things being spoken of. One is a question of joint liability, the other is a question of quantification. And it may be perfectly possible for a claim of joint liability to be made and to succeed. That doesn't necessarily tell you anything about the impact that has on quantification.
No, my lord. All I can tell you is what was in the evidence before the judge, which is that there was a claim articulated by Lufthansa against Astronics in respect of Panasonic's profits. That's all I can tell you. I can't tell you any more than that.
This is why one needs precision about what's being done in Germany. Because again, if it is correct that the nature of the claim, this is a claim for damages, but using infringers' profits as a proxy measure of loss to the property, then that's quite a difference from saying we're grabbing the profits on an unjust enrichment basis.
I completely accept that, and I can't give you greater precision. All I can say is that that is a potential claim. The precise nature of that claim and the precise quantification of that claim is going to have to wait until the German court, Mannheim 3, delivers judgment.
How does that affect the claim in England? If I've understood you correctly, what you have suggested is that there may be a claim being pursued against Astronics, maybe for damages, may take into account profits earned by Panasonic. None of that can affect the fact that no claim was advanced or had judgment given against Astronics in relation to those sales in England.
Absolutely right.
Nor can it affect, it seems to me, the moment, Lufthansa's claim against Panasonic. The fact that someone else may be held liable in Germany doesn't affect. How does it affect Panasonic's liability?
It doesn't affect Panasonic's liability. Subject to the precision of the basis upon which the award is being sought. But in principle, Panasonic has already accounted.
Well,
by way
Panasonic
of profits.
what you tell us is that in Germany, Astronics can be sued as well. So that doesn't affect Panasonic at all.
No, but if Panasonic has already paid out, courtesy of the UK award,
Well, this may be a point to be taken in Germany, but I don't see how it affects Panasonic's liability in England.
my lord,
That Astronics may have to pay more money in Germany. How does it affect
Because-
Panasonic's liability?
it doesn't go to the liability, it simply goes to the money which is being sought against Astronics in Germany.
Well,
And a
then-
part
then
of
it's-
that claim is in respect of money,
Yeah.
which
Well,
on
That may be a good point to be deployed in Germany. How does it affect what we are interested in? Can what happens in Germany in the future affect the quantum of Panasonic's liability in England for what Panasonic's do in England?
and the answer is no.
No.
No. But,
So,
but,
so
but,
where
but
does this point go?
it simply goes to an aspect of double recovery, what I call double recovery, which is Astronics have recovered against Panasonic, courtesy of the UK award, its profits, and the same profits, subject to the precise particulars of how they're formulated, are being sought from Astronics.
Yes, but not in England. So why are we concerned with it? I can see the German court might be troubled with these submissions, but at the moment, I'm struggling to see why it affects what Mr. Justice Leach has done. How it could ever affect what Mr. Justice Leach has done.
It's simply an example of double recovery, my lords, what we say is double recovery. Let me move then to the other example, which perhaps is a little easier. Consider this scenario. Astronics supplied M-Power components to a seat manufacturer such as Safran in the United Kingdom. Safran assembled those components into seats and then shipped those seats to Germany, where they were incorporated into an aircraft. The profit earned by Astronics in respect of the supply of those components in the United Kingdom has been captured in the UK award. And the same profit is potentially at play in Germany. I say potentially because the German court has yet to determine whether, and if so, what proportion of Astronics' profits should be paid in respect of infringement of the German patent. And of course, one option, one outcome, is that the German court finds there's nothing further to pay, in which case the issue of double recovery simply doesn't arise. On the other hand, the German court may make an award without reference, ignoring what has happened in the United Kingdom.
I think you need to get on to the meat of this appeal, Mr. Appellant. I'd like you to finish your submissions if you can by 12:15.
Right, okay. I will do that. In that case, let me take you.
So you've got to persuade us of two things. First, the judge had the power to make a provisional award. Second, he wrongly exercised his discretion on the assumption that he had that power.
All right, I'll go straight to those. Go to the core judgment, the core tab 20, paragraph 346. Page 346. This is the key bit of reasoning in the judgment, section E. Your lordships can skip over paragraphs 49 and 50. That's a pleading point. And at the bottom of the page, you'll see a section finality. And as we shall see, the judge goes on to conclude the court has no power to make a provisional award of profits or give the parties liberty to apply. And his reasons are essentially threefold. And can I take those in turn and then see why, or address you, your lordships, on why the judge concluded as he did? So first, paragraphs 51 and 52. The judge says that the defendants didn't point to any provision of the civil procedure rules or any principle of law that would enable the court to make a provisional award of profits. Just pausing there, I did take the judge to the case management powers available to the court under CPR Part 3.1. In my submission, what the judge is really saying there is there's nothing in the rules that expressly refers to the making of a provisional award of profits, and likewise no general principle of law to that effect. Just dealing with the judge's reasoning at this stage, he then draws an analogy with the award of provisional damages for personal injury under section 32A. And your lordships will be, I'm sure, familiar with those principles. He explains by reference to McGregor that the general principle is that award of damages must be in the form of a lump sum. And then in paragraph 52, once damages have been fully assessed, the award cannot be revisited. And just pausing there, paragraphs 51 and 52, as we shall see in a moment, the judge's reasoning here is that that's the position in relation to damages. And therefore, if that's the position in relation to damages, then it must also apply to an account of profits. Can I turn over to 53 and 54? And I can take 53 and 54 very quickly. The judge is addressing here Mr. Justice Pumphrey, as he then was judgment in Springform and toy brokers. And in 53, he gives an account quotation, then paragraph 54, which concludes that he attributes no weight to Springform in this context. I don't criticise the judge for that. That was a very different case from the one with which we are concerned. And just to be clear, when the judge says in paragraph 53 that the appellants relied upon that case as authority for the proposition that the account could not be concluded until or unless Lufthansa elected not to claim profits in the French or German courts on the same articles or products for which the English court had made an award of profits. My Lord, that's not entirely right. I was relying upon Springform as an analogous case, which provided some broad guidance as to the appropriate way to manage accounts, no more than that. But I don't criticise the judge having not placed particular reliance on Springform. More important is where the judge gets to at paragraph 55 on 349. And as we see, or as I've identified earlier, what the judge does in the first two sentences, or first sentence, is to essentially reason that whatever happens in damages should also apply in the case of an account of profits. There's no reason why it should be different. I'll just address your lordships of what he then says in paragraph 55 before giving my overall submission on paragraph 55. He then says in the second sentence, the principle of finality requires that the court must bring the proceedings to a close and give judgment on the evidence before it at trial. He said it would be impossible to draw a final line under the litigation if the court is required to anticipate what further evidence might come to light or give the parties the opportunity to re-argue the case in the light of future events. Lords, my submission to you is what the judge is doing here is imposing an unwarranted straitjacket on the court. What the judge is saying, because this is before he goes on to look at the exercise of his discretion, is that no matter what the circumstances of any case, as a matter of principle, the court cannot do anything other than order profits to be paid on a final basis. And we say what the judge has lost sight of is the court's broad case management powers to do justice between litigants in the circumstances of any particular case. Now, there will be cases in which it is plainly right for the profits to be awarded on a final basis. In other cases, it may be appropriate to fashion some other order. For example, where a subsequent event reveals that the profits paid include profits for which the patentee is not and accepts that it is not entitled. And when I say a subsequent event, I don't mean an unforeseen or hypothetical event. I mean an event that the court knows will occur and whose outcome is necessary to resolve a pleaded issue in the proceedings. And of course, I'll come on to address your lordships on the particular facts of this case, but in this case, double recovery is a pleaded issue. It is necessarily contingent upon the outcome in Germany. And therefore, to impose the straitjacket of finality, and to require that in any case, including this one, finality requires that the proceedings be brought to an end, notwithstanding the existence of that pleaded issue, is, in my respectful submission, to impose an unwarranted straitjacket in the court, given its broad case management powers. So that's my submission in relation to what I say was the error of principle. My submission is
Well,
that the court.
what case management power? I mean, I can see the argument of saying, well, the judge could have adjourned everything to await the outcome of whatever gets decided in Mannheim, and that would be perhaps within his case management powers.
Yeah.
But how does a case management power allow for a provisional award?
Well, it can allow for it in a number of different ways. I mean, the way in which it was suggested by us was to essentially provide for liberty to apply. And liberty to apply, as it were, carried with it the implication that the award must be a provisional one. But simply providing, I mean, there are other ways of formulating the outcome, but essentially liberty to apply is the touchstone. And in terms of the specific case management powers, the one that, in my submission, is of particular relevance is the express power to take any other step or make any order for the purposes of managing the case and furthering the overriding objective. That is a broad power.
So normally, permission to apply is incorporated into an order in order to prevent what would otherwise be raised judicata being raised judicata. There's cases on that, obviously, but it's a broad proposition. But why would you do that in these circumstances?
Because in my submission, the liberty to apply would be there for the purposes of working out the final sum to be paid. So the order provides for a payment sum. That payment sum has to be expressed as provisional. But given that it's provisional, the liberty to apply allows the final working out of the sum to be paid upon completion of the foreign proceeding.
Why would not the same principle apply to damages?
Well, I think the same principles would apply to damages. The difference between damages and profits is that we have certainly a statutory scheme.
But the reason we have a statutory scheme is precisely because, if you read McGregor, under the common law, it was not possible to make a provisional award of damages.
Indeed.
At the end of a trial, the jury, or now the judge, gave a verdict for a sum, and that was that, subject to appeal.
That's right.
And so that's why you needed the statute. But if you're right, the CPR contains within it ample powers to make whatever provisional award of damages you want, even outside the statute. Is that really the case?
Well, as far as damages is concerned, that is the basic common law principle. The sum to be paid has to be assessed and finally assessed on the day of judgment, or the award being made by the court, by the jury or the court. And then what the legislature has implemented in my submission is recognising that in a particular case of personal injury and the possibility of a foreseeable, although an event which is not yet crystallised, being on the horizon, allowing that award to be made provisional.
Well, it's to take account of changes in the health of whoever has been injured, isn't it? That's why it's done.
So I didn't hear you.
The health of the injured person might deteriorate or might improve,
Yes.
and the prognosis may change or whatever, and that's
Yes.
why, in those circumstances, the court is empowered to make a provisional award.
Yes. And because the
But,
court
I mean,
has...
there are plenty of other cases in which things might happen which would reduce the measure of liability. I mean, suppose somebody, I don't know, damages a building, and bring a claim for damages. The judge assesses what would be necessary to put right the building, but when you come to instruct the contractors, they found that they need to underpin it, or it's got dry rot or something, which wasn't part of the trial.
Yes.
You wouldn't have a liberty to apply just so that you could come back.
No, because that would be an unforeseen event. That is, there's no perception at the time the award is made of this eventuality. And therefore, in the absence of some anticipation that an event may happen, it's quite proper for the award to crystallise as it does. What we have here is an award of profits in circumstances where there is a known, not hypothetical, there is a known event which is on the horizon, whose effect has the potential, subject to what the German court does, to influence the award that was made.
All right.
Can I then deal with discretion?
Yes.
So paragraphs 56 onwards obviously assumes that the court does have the power, and I do respectfully submit that the judge in this case has come to a conclusion which does fall outside the bounds of reasonable disagreement. And the first of those is paragraph 56 sub 1, the issue of timing. And the judge is considering here the timing of the German and French claims. And he says that if they were likely to be determined in a matter of weeks or months, he might have been prepared to stay any final award and grant permission to apply. But not if, as is the case, they will not be resolved for a number of years. In my submission, the fact that the overseas awards will not be concluded for a number of years is not a relevant consideration. To put it another way, if it's right to give the defendants liberty to apply where the overseas awards is just around the corner or available in a few months, then the mere passage, and I emphasize the mere passage of time, cannot be a relevant consideration. In other words, if it's right to do it on a short time frame, it can't make any difference that the time will take a little bit longer. Not in this case. And that takes me on to subparagraph 2, because the key bit of reasoning in subparagraph 2 is the judge says no party, this is 3 lines up from the bottom, no party who has the benefit of a final judgment should be required to live with the uncertainty that they might be ordered to repay the fruits of that judgment. The uncertainty, my lords, is inherent in the circumstances of this case, where there is an outstanding pleaded issue that is contingent upon a future event. But more fundamental, the uncertainty to which the judge refers is, again in my submission, irrelevant. So Lufthansa, living with the uncertainty that it might not be entitled to a portion of the profits obtained in the United Kingdom. Or to put it another way, the judge has taken no account of the consequences of Lufthansa avoiding repayment of those sums, payment which it accepts that it's not entitled to. Can I then turn to subparagraph 3? The judge here reaches a conclusion that there is no risk of double recovery. And in relation to Germany, he says Mr. Appellant didn't challenge Mr. Yapel's evidence in relation to defence of performance under German law, or argue they would not be able to deduct the profits which they're ordered to pay by the English court, either as costs of manufacturing or as a matter of general principle. I ask your lordships to look at Mr. Yapel's evidence. And that is, I'll just give your lordships a reference to the bundle. So it's in the supplementary bundle, tab 4, and it's paragraph 30. And in fact, what the evidence from Mr. Yapel was that the defence of performance was available in Germany. He didn't say that it would succeed, and indeed the evidence was that the strongest could object to any further payment, and if successful, it would limit the German award. Now, of course, what one has to bear in mind is that we don't know at this stage what the outcome is going to be in Mannheim 3. And both sides recognise that one possibility is that the German court approaches matters and concludes that it will take no account of the outcome.
Well, what he says is that question of double counting will arise in subsequent proceedings, and any German judge would have to take such defence into account.
Indeed, have to take it into account,
Yes.
but not necessarily reach a conclusion that says,
No,
yes, I've
because he
taken it
might
into account.
say it's factually incorrect.
I say may decide that decide against its inclusion as part of the accounting exercise. Subparagraph 4, the judge then approaches it on a different basis, which is even if there is a risk that the French or German courts would permit double recovery, he concludes that this should be a matter for determination by them, that is to say the foreign courts and not the English courts. Now it's plainly a matter for the foreign courts to decide what award to make in their own jurisdiction on the basis of their own procedural and substantive laws. In my submission, what the judge has overlooked here is that because double recovery is a pleaded issue in these proceedings and is contingent upon the outcome abroad, what the judge has left out of account is the potential for the double recovery award, or the award in Germany, to have an impact on the award that he had made, and which the English court has made in the original account. By way of example, if the German court decides to award profits, irrespective of the UK award, we would wish to contend that that payment made in Germany should constitute a cost in the overall business in this supply chain.
Well, it seems a very odd way of doing it. Normally, one would have thought that if you were dividing up profits, you'd first work out what the profits are, and then you'd work out if the patentee was entitled to some, and if so, what portion of them.
Indeed.
And if the English court says you're entitled to 13% of them, and the German court says you're entitled to another 50% of them, the patentee gets 63%. What's wrong with that? It doesn't change what the pool of profits is.
No, what it does do is it changes the net profits which are available to be apportioned. So the 13% that's been awarded in the United Kingdom is payable on a profit pool. Now, if the award that's made in Germany constitutes a cost,
it doesn't constitute a cost, it constitutes a division of the profits. So what I would assume, obviously it's a matter for the German court, how it does these things. But the way I would imagine an English court to look at it is, this is your profit, say 10 million, and the patentee gets 13% of that, 1.3 million. German court would do the same. So this is your profit, it's 10 million. Wouldn't take off the 1.3 million. That's not a cost of doing business. That's a division of the profits after you've arrived at the profits. 10 million, you get 50% of that, it's 5 million. That doesn't affect the fact that the English court has correctly identified the profits as 10 million. The profits don't get down to 5 million because you have to give 5 million of them to someone else in Germany. It's a division of the profits after you've arrived at the pool of profits. It doesn't shrink the pool of profits.
well, the Lordship obviously doesn't agree with me.
Well, that's my instinctive reaction. But it's
what I'm making a submission to you. Let's put it this way. Let's assume that the finding in Germany was not a prospective one, but was a finding which had been arrived at 2 years ago. Astronics, when you sell this into this particular supply chain, you will have to effectively indemnify your customers for any liability and any payment which they're required to make when they commit an act of infringement in Germany. That is a cost, I would submit that that is a cost which is to be factored into the overall business.
Isn't that made the point that this is essentially a question of comedy? If you had a German decision first, then the English court coming to the notice subsequently to make sure that it took that into account and applied its own law accordingly. As it turns out, matters the other way around. The English court has made a decision first. The German court will have to take that into account. Again, applying its own law. So each court has to trust the other to apply its own law in the correct way.
Indeed. And there's no part of my submission that involves challenging the legitimacy and the appropriate course that the German court wishes to take. My submission is, I'll make it as briefly as I can, my submission is that the account in the United Kingdom proceeded on a known set of facts.
Yeah.
In circumstances where there is an outstanding fact.
Yes, which is known about but has yet to materialise.
Indeed. My Lord, may I'll just wrap up what you have now passed. What on discretion? What we invite your lordships to do is to exercise that discretion afresh, and to exercise that discretion afresh in the following circumstances. The patentee accepts that it's not entitled to recover in the foreign proceedings the same profits in relation to the same product. There is an issue, indeed a pleaded issue, as to what are the same profits in any particular circumstance. That issue is only capable of being resolved once the foreign court has given judgment. The foreign court giving judgment is, as I've said many times, not a hypothetical event, but a known event. The only uncertainty is when it will happen. And the appellants are, in my submission, plainly prejudiced in the UK if the UK award turns out to exceed the profits for which they are liable. And that, of course, assumes that in that accounting exercise, it is legitimate to take in the German award as a relevant cost. On the other hand, there's no prejudice to Lufthansa if it has to repay profits to which it's not entitled.
Thank you, Mr. Appellant. Who on the Lufthansa side is dealing with this one?
It's my job, my lord.
Right.
I'll take this very quickly. I've got 4 headline points to make. The first is that this appeal is a procedural Ouroboros. Astronics is concerned about possible inconsistencies between the UK, Germany and France. In the event that something happens overseas which they consider to be inconsistent with the outcome here, they wish to be able to reopen the account. But by parity of reasoning, they, or Lufthansa, will want to have the same freedom in Germany and France. What is a good result for one is a bad result for the other. Astronics got a great result in the UK. It wants the UK to assert control over the multinational proceedings. When the courts in Germany or France reach their conclusions, those will involve a decision whether and how to accommodate the UK decision. If one subsequently seeks to reconcile here, the German and French decisions will have been reached in ignorance of that reconciliation. So again, by parity of reasoning, someone would then want to reconcile in Germany in light of the reconciliation in the UK, and so on and so forth. That is where the logic of the application leads. We say it is procedurally insensible. Secondly, we say it's unnecessary in any event. For the reason my Lord Justice Arnold said, this is really a question of comity. And if one trusts the overseas courts to take care with their decisions in light of the UK decision, no problem arises. But in addition, we have fortified Astronics with a clear and open statement in our points of reply, which Astronics is free to deploy overseas. And we believe that fairly answers any legitimate concerns.
Well, there's a combination of things, isn't there? First of all, you accept that you're not entitled to recover profits in overseas proceedings where an award of the same profits has already been made in relation to the same physical products.
Yes.
And there is a defence in Germany of performance. And in light of your statement, it's difficult to see a reason why that defence shouldn't succeed.
Well, so the challenge for my learned friend is to persuade my lords to interfere with the judge's decision as being effectively procedurally insensible in light of that protection. What is the exposure? This must be an application under the overriding objective. What is the exposure, the injustice which is likely to occur in that context? And that brings me to my third point, let us assume, in my learned friend's favour, the judge had power to retrospectively declare the trial to be an interim decision. The touchstone for any decision about what to do is the prejudice asserted in Astronics evidence. Is that something which the court can and should take steps to address? Now, if you have my learned friend's skeleton, paragraph 69, so that's core bundle. I have it loose. Core bundle. You'll probably find it before I get the reference. I think it's tab 10. I'll respond to tab 9. Page 180. They give an example of a power supply being fitted into a seat in the UK and then being installed onto a plane in Germany. And they say this: there is only one transaction that caused a profit to be generated for Astronics, the initial supply of components to Safran in the UK, for which Astronics has already been ordered to account in the February judgment. Accordingly, any award by the German court in relation to such components would necessarily be in respect of the same products and the same profits. Now, we accept that there is only one transaction for which Astronics was paid, but it's not accurate to say that Astronics has been ordered to account for that transaction. Astronics has been ordered to account for the profit derived from acts of infringement of the UK patent. Those are different from German or French acts of infringement. The law of profits is different in Germany and France, and the German and French acts are in relation to different patents. As a result, the overseas proceedings may be concerned with the same products, but they're not concerned with the same conceptual profits. The commonality lies in the products and Astronics' income. That's why the right solution is for the UK award to be treated as a deductible cost, not some sort of res judicata. If the German award were lower, it would be wiped out because there would be no refund to Astronics. If the German award on that product were higher, there is a simple deduction in respect of the corresponding UK award. The key differences can be demonstrated by reference to the current positions in Germany and the UK.
Right, so are you saying that the UK award can be deducted from any award made by the German or the French courts?
If one considers the trade in the profit, the trade in the product just for Astronics, our concession is that the profits awarded here are a cost of that business and can be asserted as a cost of that business in Germany, just like the materials cost or the labour cost.
Right, so you are asserting that the quantum of the UK award can be deducted from from the foreign award or from the pool of profits to which the foreign award applies.
The effect of that acceptance is a matter for the overseas courts in the context of the particular quantum claims, or whatever claims they are, that are asserted overseas. But as a matter of principle, what we are saying is that is a cost of doing business, a cost of that trade, which is available.
That reduces the pool of profits. It doesn't reduce the award.
I can't say to you that that is inevitably an answer to every conceivable problem, but what I can say is Astronics haven't explained a problem that remains. Now, it's important to keep in mind that in Germany, Claim 1 of the counterpart patent was held invalid. Claim 2 is to a timing feature, which has the effect of imposing a pin symmetry test on whatever plug is being introduced into the socket. It's an additional feature. That was valid and infringed. But Astronics were able to design around Claim 2 in a way they were never allowed and able to design around claim 1. They had a non-infringing alternative, and that is proper. The German court took that into account and still awarded 50% profits. Now, without going into the question of who is right and who is wrong, that award is totally at odds with Mr. Justice Leach's award of 13%. In effect, the German court assessed claim 2 as a Mercedes or BMW patent, and the English court assessed the far more broad and powerful claim 1 as a second-hand Austin Allegro. Different patents, different law, different evidence, but not unrelated objectives. Now, in that context, if you turn please to the judgment on double recovery, Core Bundle tab 20, page 344, this is the evidence upon which you're being asked to interfere with this decision. It came from Mr. Stoll, and he's giving voice to Astronics concerns. And at paragraph 83A, this is in the quote, towards the bottom of 344, Mr. Stoll records in substance the analysis we've just been looking at. And I've explained why we disagree with it. And then he says this, it is clear from Lufthansa's second letter of 14 March 2025 that Lufthansa nonetheless intends to claim in Germany in respect of the same transaction. For example, by arguing that the 87% that this court has not attributed to the infringement are somehow available in Germany and are not the same profits in respect of which a determination has been made in this account. Well, to be clear, we do contend that the 87% of unawarded profit is available in Germany. They're not the same profits, they're not the same acts of infringement, they're not the same patents. But we accept that the 13% awarded here are candidates for the same profits. They are overlap profits. But read on, please. Mr. Stoll says this. If that is the case, the defendants wish to argue that the recovery of such profits would be relitigating an issue that has already been decided by this court and amounts to double recovery. That would be totally hopeless if the German court had gone first. The law's different, the evidence different, the infringing acts are different, but most fundamentally, the inventions are different. But this is the justification, this is my learned friend's justification for the interference that is urged upon you. But the German court didn't go first. So Astronics wants liberty to apply so that they can argue here that the German court should have considered itself bound by the UK decision. That is hopeless squared. It is also a paradigm matter for decision by the German court, whether and to what extent it considers itself constrained by the UK decision. Fourthly, this seems to us a problem inherent in any account of profits. There is always the risk of a subsequent event which retrospectively changes the infringer's profit position. Assume there are no overseas proceedings at all. Astronics might be vexed by a third-party infringement claim or a product liability claim. But the courts just go ahead on the basis of the facts as they stand and draw the account, and then it's over. You don't leave a liberty to apply just in case something happens later, which might have had an effect on the sums. There has to be finality.
You could have adjourned it. If there's an imminent decision which will radically affect things, you can always adjourn your decision.
Yes, right. And that actually brings me straight to the first point of principle, which is the purported error in not, what we say, retrospectively calling this a preliminary issue or an interim decision. Up to the date of the trial, the judge is managing the proceedings in the normal case management in accordance with the CPR. He can direct a preliminary issue, he can adjourn, he can call it an interim, he can say this is going to be an interim trial, anything. But this was all afterwards. He's heard the trial. His role then is to settle the term of the order, deal with costs, and he's done. And as he said in his judgment, it's then a matter for the appeal. It's not right to say that the general case management provisions of the CPR then allow him to pretend that the final trial that he's heard is something else. And in relation to that, it's important not to lose sight of the fact that all these concerns are entirely contingent. My learned friends in their skeletons say that the relevant overseas event is certain to occur. But that's clearly not right. If everything proceeds overseas in accordance with their hopes, there would be no need to use this liberty to apply. And so in that regard, it's no different from the damages for personal injury situation which the judge referred to and relied on in his judgment. Well, that just leaves the discretionary concerns. I don't know if you want to hear from me on those or whether you're happy to take a short submission from our skeleton argument.
As you please.
So, my lords are obviously familiar with the very high degree
Yes.
of latitude to be given the exercise of the first instance judge's discretion on case management issues. The complaints do not approach the necessary threshold. And there's one overarching piece of context here, which is appropriately enough the overriding objective. CPR 1.12d requires the court to deal with cases expeditiously. The corresponding whitebook note suggests that the long-established principle of finality of litigation is inherent in the overriding objective. That's the whitebook volume 1 at section 1111. We suggest that requirement in and of itself disposes of this appeal. The judge cannot be criticised for conforming with the requirement of finality of litigation. And trusting overseas courts not to bring about an outcome that this court would consider inappropriate. The second complaint is that the judge considered the consequences only of granting liberty to apply, but not of refusing it. We don't think that's a fair criticism. If you see his judgment at paragraph 56, so 56.2, he considers the consequence of granting liberty, and at 56.3, he considers what evidence there was and decides that there was no real risk that the overseas courts will permit double recovery. That is an assessment of the detriment associated with refusing liberty to apply. The third point is about the foreign law position. Astronics say it was not open to the judge to find that there was no real risk of overseas courts permitting double recovery. Well, as to Germany, there was evidence from Mr. Jekyll, Lufthansa's German attorney, and his evidence was to the effect that the defendants could raise double recovery and that the German court would take it into account. We submit that must be sufficient. As to how the German court would deal with the problem, there was no evidence, but the presumption of conformity with UK law fills that gap. So without any positive evidence to help this position, my own friend can't get any prejudice out of that. And that then disposes of the position in France as well, where there was no evidence. If he wanted to make the point that there's going to be a divergence of practice, the burden was on him to prove that a foreign court would take a different course. Fourthly, the defendants attack paragraph 56.4, where the judge expressed the view that it was a matter for the foreign court to consider the degree of overlapping profits when coming to any view as to the appropriate sums to be awarded. That was very obviously a decision that was open to them. The defendants are, in effect, inviting this court to adopt a multinational supervisory role, and the judge, we say, was not obliged to accede to that invitation. Lastly, they say he was wrong to rely on the principle of finality, and I've addressed you on that already by reference to CPR part. Unless I can just any further
Thank you, Mr. Cuddigan. Mr. Ackland, do you wish to reply?
Just on one point, my lords, my learned friend says that we haven't explained what the problem is with the approach which my learned friends have taken in their pleadings. That is to say, they set out what their position is on double recovery. I can explain by reference to one letter which sets out precisely what the problem is, illustrates precisely what the problem is. It's in the supplementary bundle, tab 14, paragraph 18, page 184. And could I ask your lordships to read the paragraph that starts, notwithstanding the above, that begins against the second hole punch?
Yes. Yes.
So that proceeds on the assumption that the German court makes an award without reference to the UK award. There's an acceptance there that a proportion of that award would be money that should be paid, or money which was repayable to Astronics. But what the Lufthansa's position has been throughout is no undertaking will be given to repay. So they obtain money from Germany, or a proportion of the award in Germany is money which they accept it should be treated as a deductible cost. But there's no means of extracting that money from Lufthansa.
I don't see this. What they're saying is, if the UK court awards $1 and the German court awards $3, they'll collect $1 in the UK and only $2 in Germany. There's no repayment of anything.
But what's happened on this assumption is that the German court has awarded $3.
Yeah.
Yes, and they say they will only collect $2 of it.
Saying they won't enforce it to its full extent.
Well, if this is to be read as we will not seek anything more than $2 and not seek to recover in the German courts anything more than $2, then that's right. But since it proceeds on the assumption that the German court has been asked to rule and makes a decision without reference to the UK award, well, it must follow that they end up with $3 in their bank account because
That's not how I read the last sentence on page 184.
Okay. But interestingly, in the same letter over the same page, despite refusing to give any undertakings, you will see at the end of the main paragraph, which starts the re-amended points of reply. They refer to a particular supply chain. They say your clients have advanced no justification for such outcome. Lufthansa doesn't offer any concession. Nonetheless, we confirm that our client will not object to your clients having liberty to apply in the event Lufthansa will fail to act in accordance with its pleaded position in paragraph 30 of the re-amended points of reply. Bang on.
Yeah.
That's it, my lord.
Thank you. So that leaves, I think.
Yes. everyone is now noting, a little short on time. Obviously, we're in your lordship's hands. I know the friend has taken more time than we have to date. The even split hasn't quite worked. But obviously, your lordships will want our need to hear as much as possible, no doubt, in accordance with the points that you're interested in, and I can't prejudge that. So I'm not going to take a
Could you
point
speak
on
up,
the
Mr.
timing.
Further? Sorry.
Sorry, my lord.
Could you speak up a bit?
I'm sorry. I'm not going to take a point on the timing and who
No,
has
right.
more time than whom, because we're in your lordship's hands, and I will just try and proceed as swiftly and as
Yes.
efficiently as possible. He says, I want to put the thumbs away. My lords, this appeal on interest raises points of principle as to the basis on which interest may be available as ancillary relief after an account of profits for infringement of an intellectual property right. And it also raises a point of practice in terms of how to approach such an award of interest so far as it concerns the appropriate rate to be applied, and potentially whether deductions for taxation in the hands of the infringer should be made. I'll come to the detail of that towards the end. The main point of substance is the question of whether interest on an account of profits for IP infringement is recoverable for periods prior to the date at which the profits can properly be said to be owed as a debt to the claimant, which we say is the date of the election in accordance with the judgment of Lord Briggs in Lucadzi. We say that they are not so recoverable unless it's proved that the defendant actually made money in the form of interest on the profits, in other words, profit on the profits, which could be recovered as part of the account itself, which would obviously give rise to questions of remoteness, and you've already heard examples given where that might or might not be done. Of course, in this case, no such claim in the account was made for profits made as a matter of fact. All that is sought, or was sought and was awarded by the judge, were what are occasionally referred to as objective interest, that is to say, interest taken at a standard rate, as it were under Section 35A of the 1981 Act, or under the court's equitable jurisdiction. Can I make some big picture points first, because this case has been argued out in particular by my learned friends in their responsive skeleton in quite a big picture way, and then go to the details of the law. We submit that much of Lufthansa's case follows the same reasoning as the courts in Sempra Metals, which turned out to be faulty, by treating the mere fact that profits were in some sense in the defendant's possession and were later ordered to be handed over, gave rise to an automatic right to compensation from whatever date the profits were deemed to have been made. Whether that's expressed as they do, time value of money, whether it's expressed as they also do as an opportunity to make money. But that, what I describe as a faulty argument, was of course rejected firmly in Prudential. I'm going to show you the relevant passages where they look at the question of, in that case, restitutionary basis for interest, but it's the same principle in our submission. And of course, in Sempra Metals, it led to the fallacy on this ground of a compound interest award, because the logic just flowed through in that way. And that's we submit the basis of the claim which is expressly being made in the Land of Friends skeleton, founded on the concept that there's a fundamental right to restitution of the benefit or time value of money which the defendant shouldn't have had, and that is what can be dealt with by a simple notional award of interest. And you'll note from the Land of Friends skeleton, they rely in paragraph 10 and elsewhere in particular to the judgment of Mr. Justice Henderson in Littlewoods and RCC. If you could turn up our skeleton in response, you will see what we say about that between paragraphs 10 and...
Which tab is that? Tab 11, is it?
Oh, sorry. Yes, it's tab 11. So I've been using a separate copy. So this is the passage where we deal with their time value of money argument and the reliance on Mr. Justice Henderson in Littlewoods. And as we say in 11, the time value of money, we agree, can be a useful concept. It's different from valuing the benefits which a defendant actually received from the use of the money. And certainly Mr. Justice Henderson considered, by reference, of course, to Sempra Metals, in particular passage of the judgment of Lord Hope that we're going to come to, that an objective assessment should be made in that case, which led to the award of compound interest. But of course, first of all, we say Littlewoods was a very different case from the present. It was one of those series of cases about money in the hands of the government and the basis upon which it should be returned. And what, as we say, Mr. Justice Henderson relies on is that passage from Lord Hope in Sempra Metals, which we quote at paragraph 13. And it's important just to see what the philosophy here. The measure of the right subtraction of the enrichment that resulted from the money's receipt does not depend upon proof by Sempra of what the revenue actually did with it. It was at the opportunity to turn the money to account during the period of the enrichment that passed from Sempra to the revenue. This is the benefit which the defendant is presumed to have derived from money in its hands. And as we point out in 14, this was precisely the point which was overturned from Sempra Metals in the case of Prudential, and that the Supreme Court in that case explained that there was no basis for interest to reverse so-called unjust enrichment in relation to a money hadn't received case. And if we look, please, at the Prudential case, which is authorities 4, I think. Authorities 4, 3, 2.
4, did you say?
Yes, at 3, 2.
I think it's authorities 3, tab 57.
I beg your pardon, that was a different reference. Yes. Right. turn to paragraphs. I would invite you to read, get the opportunity, everything between 70 and 80, but for the purpose of cutting through this, one can look at what they say about the right to interest in a money having received case from paragraph 75. And the court here has set out an analysis of why it is that interest is payable on money, in their view, on money which is being claimed by way of unjust enrichment. And essentially, in the previous paragraphs, they said it's because a debt was created when the money was handed over under mistake, which caused it to be, as it were, immediately repayable in the hands of the defendant. And as they point out in 75, there are repeated authorities that before the statutory right to interest, the courts would not order interest to be payable in a money hadn't received case. So the mere fact that there was money sitting there in the hands of the defendant, which ultimately the court ordered to be repaid, did not mean that there was some further right to claim more by way of interest. And 76 and 77, they set out the basis upon which interest is payable, and they refer to Lord Wright and his statement in Richards and Westminster Bank. And this is an important statement we submit. The essence of interest is there's a payment which becomes due because the creditor has not had his money at the due date. It may be regarded either as representing the profit he might have made if he had used the money, or conversely, the loss he suffered because he hasn't had that use. The general idea is that he's entitled to compensation for the deprivation. And again, in 77, once it's understood the claim to interest is not truly based on unjust enrichment, but on the failure to pay a debt on the due date, the conclusion inevitably follows that interest can be awarded on the claims. And then again, without getting into the weeds of the various categories and what was payable and why, you see in the first few lines, section 35A applies only where there are proceedings for the recovery of a debt, damages. But the key here is, until the money is a debt payable in the hands of the defendant, there is no basis for regarding the claimant as having some kind of restitutionary entitlement which can be dealt with by way of a statutory interest award, or we would say any objective interest award. Of course, as happened in Sempra Metals, in the part of the decision that wasn't overturned, you can have a claim to interest as damages if you have suffered loss on that basis. But that is a claim to damages, a separate freestanding claim. It is not the objective statutory attempt to regulate the position in accordance with the time value of money.
I think inherent in your position is that the debt does not have to be quantified at the date when interest starts to run.
Yes. Yes, there is. We don't say that the debt only arises when the judge finally resolves it. That's absolutely clear on the authorities. But the debt arises when it is crystallised by an act, in this case, because there has to be an election. And that's what Lord Briggs is talking about in Vacancy, and why he says it's different from a case of breach of trust, where from the moment the profits have been made in breach of trust, they effectively belong in equity to the defendant, the claimant, and there is therefore an obligation on the part of the trustee notionally to invest them, make money, and so forth. Utterly different, the passage that you'll have seen, we've quoted in our Stella, when it comes to an account of profits which exists purely as a remedy which arises from the date of election. At that moment, it's fair to say there's a debt, albeit it hasn't been fully worked out between the parties, but it exists as a notional objective sum. And one can fairly say that from that moment, because of course, until that moment, the defendant doesn't even know that profits should be handed over, it needs to be handed over, plus any interest that then emerges, to protect the position of the claimant, who should have had the money when he made the election. So that's really the big picture, and we say it's a big picture under Section 35A, and it would be very strange if the equitable jurisdiction was different in principle. I think someone remarked earlier.
Seems that part of your argument is what a question of retrospectivity, because you accept there's a debt as from the date of the election, and in effect, I know you haven't quite put it this way, but in effect, you say, well, that doesn't have any retrospective effect, but court decisions constantly have retrospective effects, don't they? The mere fact that there's a finding of infringement means that there's a liability where parties didn't previously think there was a liability.
Yes, but there needs to be some basis upon which you can say, as a matter of policy, that the defendant has been kept out, the claimant has been kept out of his money. And this is the justification that's constantly given by the courts in the interest cases.
But
and
if we're thinking about statutory interest,
yes,
and the patentee sues for damages, my account of profits, just damages,
yes,
would you accept that interest runs from the date when the cause of action
yes,
arose?
precisely because that's a compensatory remedy, and it's then provided for by Section 35A.
Right, so by electing to take an account of profit, a patentee does himself out of possibly a year's worth of interest, which otherwise he might have got.
Yes, it's a very different claim, obviously. An
And
account of profits.
why can a patentee not say, you have infringed my patent, I have a claim for debt or damages, I haven't actually decided which yet.
Sorry, but you mean an account or damages? I'm sorry.
Yeah. Well, the statutory language is debt or damages, and debt is very widely interpreted. But why can't the patentee fit into Section 35A by saying, I've got a cause of action, and the relief I'm entitled to is debt in the wide sense, or damages common law, and I haven't decided which yet, but my cause of action is now on foot.
Well, if I may, he has two alternative remedies, which are damages or an account of profits. He hasn't got until, in accordance with Law Briggs, the election is made, he hasn't got a cause of action for debt.
Well, he's got a cause of action, one or the other.
He's got a cause,
we know that.
He's got a cause of action.
He must have a cause of action, because he couldn't issue his claim form unless he had a cause of action.
He's
Cause of action is infringement.
He's got a cause of action for...
Section 61, as we saw.
He's got a cause...
That's his cause of action. In fact, he hasn't yet elected. Doesn't mean he hasn't got a cause of action.
No.
Your point is, he can't say, I've got a cause of action in debt until he elects.
Yes. He had a cause of action from the beginning for infringement. He hasn't got a cause of action for recovery of the debt, to take the language of Section 35A. until he elects. And from that moment, so far as profits are concerned, he can say, well, that's now a debt, and I can recover from that moment on. Because of
Yeah, so there's a big difference between damages and debt.
yes,
Or damages on account of profits
yes,
in the 19th infringement case.
yes. And damage is all about compensation, and the defendant is being put in the position that he should have been had there been no infringement, and it's consistent with that that he can recover interest because the assumption is on his part he has lost an opportunity to invest the money that he lost as a result of the infringement, the lost sales monies, and he's given that benefit because obviously he can't necessarily prove exactly what he would have done with it, but as a matter of policy, the courts assume, statute assumes, he can have compensation for the loss
Right,
of that
shall we
opportunity.
leave it there for this morning? We've got to finish this afternoon. I don't know whether you and Mr. Cunningham have discussed the timing of this particular appeal, but everything else is overrun so far, I think. But, can you make sure that your submissions, his submissions, or whoever's going to do it on the Lufthansa side, and any reply are completed by 4:15. Very much, 2 o'clock.
Advice able.